Good evening. Welcome to Pitt County Planning Board meeting. To the people out in the TV audience, Barefoot, will you lead us in prayer, and Matt will lead us in Pledge of Allegiance.
We do thank you today for this day, for all thy many blessings, Lord, and we just pray now that you would watch over this meeting tonight, and for everyone who speaks or has a part. And thank you for the blessings of life. In your name, amen.
Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next up is the approval of the April 18th meeting.
Motion to approve.
Second.
Have a motion to approve the minutes and a second. All in favor, voting by saying aye. Aye. All opposed? Okay. Next up, we have Chris.
Good evening, Mr. Chairman, members of the board. Tonight, on the development review portion of your agenda, we have one item. This is a preliminary plat titled Luke's Landing. And just before I go any farther, I kind of want to discuss, this site was the subject of a rezoning several meetings ago, and I just kind of want to remind everyone that the rezoning review and the subdivision review are supposed to be completely separate. So tonight, we're just reviewing this subdivision plan for compliance with the subdivision ordinance. So let's move into a little locational information. So this site is located on NC 33 east of its intersection with Tucker Road. It's in the Grimesland Township, proposed to be 145 lots and just under 67 acres. So here you can see its location within the county. It's just east of Simpson's ETJ and just west of part of the municipal limits of Grimesland. So here we've got a few more maps, a little more zoomed in. Again, on the left, you can see Grimesland, a little bit of Greenville and Simpson. And on the right, we have just the subject site. So I'm going to get into it a little bit later. Part of the property is in the floodway, and I just wanted to represent this on the map. You can see a sliver on the most northern piece of this property here, just under the Tar River. So the Tar River's in the light blue. The red is the floodway, and then the blue is also in the flood zone. This is the preliminary plat that's been proposed. It's a little difficult to see on the screen here, but to orient you, the far left is Highway 33 East. The far right is the Tar River. The top would be the Moss Bend neighborhood, and south would be towards Holly Ridge Estates. So some site information. Like I said earlier, a portion of the site is within the 100-year floodplain. It is zoned suburban residential, which requires a minimum of 12,500 square foot lot size. Electricity is going to be provided by Greenville Utilities, and water will be provided by Eastern Pines Water Corporation. So next, let me go into some conditions and requirements. I'll start with comments from the planning department. So we just want to ensure that lot 108 meets the minimum lot width of 75 feet when measured at the front setback line. A 40-foot buffer berm is shown along Highway 33 East, and a 10-foot landscaping buffer shown along the western property line of the Gonzalez property. We just say if these are intended to be easements, you need to please note or show as such on the plat. Next, we have sewer service must be approved by utility providers prior to construction plan submittal. We would ask the developer to submit a certification of service with submittal of a construction plan. And all this is within the county, we mostly have septic tanks, and this is going to be on sewer, so we want to make sure GUC's got everything straight with the developer prior to approving any construction plans. And then we also want to ensure all lots are within 400 feet of a fire hydrant. So more planning conditions. Fontana Drive and Slade Court are both duplicative road names and must be changed, and a wetland determination will be required with the submittal of a construction plan. Just a few more from the planning department. This development will require the installation of BMPs or a private payment to a private mitigation bank or a payment to a private mitigation bank or the Environmental Enhancement Program to meet the nitrogen and phosphorus loading requirements of the stormwater ordinance. The developer will be responsible for maintenance of stormwater BMPs for the first 2 years. Afterward, an HOA can be established and assume maintenance. So on to some conditions from engineering. Barricades need to be installed at the end of phases when appropriate. The crossing needs to be shown where internal road crosses the water feature. And that'll be shown in more detail in the construction plan. And we need to show the cross pipe that will be placed at the entrance to this subdivision. Okay, the United States Postal Service, they require cluster mailbox units, and they ask that they be shown near the intersection of Angela Lynn Drive and Fontana Drive, and that they are shown on future preliminary plat submittals. So Greenville Utilities Commission, this is specifically for electric service. They ask that they please wrap the electrical easement on Slade and Leonardo Courts to midway of the cul-de-sac, that all fire hydrants are outside of the electrical easements, and that if water and sewer services encroach into electrical easements, the easement goes from a 10-foot to a 15-foot easement. The next slide is also Greenville Utilities, but this is specifically sewer. And just like it says on here, GUC has revised their comments since our agenda was distributed and approved the preliminary plat with no comment. So your agenda you have, we'll say a few more comments, but they wanted to revise those just to say approved with no further comment. And the last comments we have are from the Department of Transportation. A left turn lane will be required on 33 East. Pavement width should be a minimum of 26 feet face to face. All utilities should be installed within 5 feet or less from any right-of-way line. A driveway permit will be required. And they ask that the curb and gutter be standard and not the rolled curb type. So next, I'm going to go into a few pictures of the site. If you look at your screen, on the left is the picture itself. On the right is a map of the site. It's got a red arrow of where I'm standing and what direction I'm facing. So this first one, I'm just standing right next to 33 East facing north. This side, I'm standing in the same spot. I've just turned to my left back towards Simpson along 33 East. This one, I have turned back to my right facing towards Grimesland, again along 33 East. So this picture, I've kind of moved onto Trip Trail, which is, if you look at the map, there's a row of trees. That road runs right between those row of trees, and I'm just facing towards the property. This next picture, I've moved up Trip Trail, and I'm standing right where there's that big growth of trees, and you can kind of see the drop-off in that area represented on the picture. So again, I continue to move further north. This is a picture of the field facing the Moss Bend subdivision, so it's facing west. This is a similar picture. I've just turned to my right a little bit, again facing that open field. And this is just facing back towards 33 East, but you can see the trees there. This picture is all the way at the back of the property along the Tar River. You can see this is going to be the location of the boat ramp area, and I think this is the area is labeled as recreational area on the plat itself. You can kind of see the drop-off where the Tar River is and where I'm standing. And then one more picture, I just have kind of turned around and faced back towards the front of the property here. So for the plat itself, for our review of the proposed subdivision, we have not received any comments on the technical review of this plan. And then the technical review committee does recommend conditional approval of the plan. And Mr. Chairman, at this time, I'd be happy to review anything or take questions from the board.
Anyone have any questions for Chris before we open it up for public hearing? Anybody? Chris,
It's public comment too.
Public comments, okay. Okay, before we open up for public comments, just to remind you, we have 3 people that have signed up for public comments. The 3 speakers that have signed up, please make sure that you limit yourself to 3 minutes. I know it's very important that you get what you want out, but also be mindful that we have other people that would like to speak also. So limit yourself to 3 minutes, please. And also I'd like to welcome Mr. Henby.
Thank you.
Okay. So first up, we have Mr. Landon Weaver. If you could, when you step up, please state your name and your address.
Landon Weaver with Bill Clark Holmes, representative for the developer with the application. And we are coming before you with a plan that meets all the technical requirements of the county. We went through the rezoning process, and now we're at the preliminary plat stage. We are moving forward, just as we said during the rezoning on how we would like to approach it. We're providing some buffers in the areas that don't have natural buffers along the Moss Bend side, as well as going to be planting buffers onto the Fontana's property that they're going to keep all the way down on Trip Trail on their property for a buffer as well. So we've gotten in touch with DOT. We sat down, asked them what they would like to see on Highway 33, and they proposed the left turn lane and widening for that center lane for folks to get out of that curve and get into the subdivision and not cause any problems for folks traveling through. It's going to free up through traffic when folks are turning into the neighborhood, and we think that is definitely needed and plan on installing that. We also have stormwater BMPs to take care of the ordinance requirements and needs on the site to handle stormwater. We're going to meet all the zoning requirements that we have, and I'm here for any questions that the board may have for us that stand out and try to be as informative as possible on this site.
Okay. Thank you. All right, anybody have any questions for Landon?
Thank you, board.
Thank you. Next up, we have, is it Rich Brown? Okay.
Good afternoon. I'm Richie Brown, representative with Stroud Engineering, doing the design on the site. Just here to answer any questions you may have from the design aspect that Landon may have not have already answered.
Any questions for Mr. Brown? Okay. Thank you, Mr. Brown. Next, we have Miss is it Holly Hogue?
Thank you all. I'm Holly Hogue, 2813 Drake Mallard Drive, and I'm representing Holly Ridge subdivision. So if I run over 3 minutes, I hope you'll give me just an extra minute or two. I have to get out the big plan because I can't see that little tiny thing that they've furnished me. Before I comment on the technical specifications, which I know Chris mentioned, and I'm sure was partly directed at me, that we don't retry the zoning decision here. I did want to take just a minute to thank all of you for listening to our concerns when we brought them forward initially about the zoning change from rural residential to suburban residential. We felt that you heard our concerns seriously, and we especially appreciated those of you who supported us. As you know, the commission voted against us, despite us turning out about 200 people for 2 meetings, and we thought writing a very persuasive document about how this decision did not meet the goals of the comprehensive land use plan. But that decision was made, and I just wanted to let you know in person that we're going to exercise our legal rights as 3 homeowners associations and a number of individuals to file an appeal this week of that decision. As that's going forward, I don't know what the outcome will be. The attorney told me one possibility might be is that it could go back through the whole process again. So you may see me again. It's kind of like the movie Groundhog Day. So that being said, we did meet, all of us, and discussed the preliminary plat. We had a couple of comments. I understand from Chris that this is a technical review, and if it meets the minimum standards of a Pitt County subdivision ordinance, it will likely be approved. I'm not an expert in this, none of us are, but we did have a few comments to make that we hope you will be vigilant on our behalf in kind of overseeing this, but also when the engineering and environmental reports come back on stormwater management. One of our major concerns remains flooding. This property has a lot of wetlands. The pictures didn't quite reflect some of the lower areas of this property. As you can see from the plat, it borders the Tar River and the Philippi Creek area. Some of it is in with the 100-year and the 500-year floodplain. And so we are concerned that putting in 145 lots, driveways, roads, and streets is going to greatly increase the impervious surface and cut down a lot of the vegetation that would have absorbed this water in the past. And this is a particular concern of the Gonzalez and Hardy families at the front. My husband and I have been in this area for 30 years. We were here for Hurricane Floyd, Hurricane Matthew, and the unnamed event that came after. This area was underwater. This dangerous curve on Highway 33 was completely underwater, and we're worried that this is going to increase the water flowing in that direction. I know that the plat calls for 3 stormwater retention ponds. This is kind of a common solution to this problem, but I have confirmed this with a couple of experts at UNC. Stormwater retention ponds don't do anything for flood risk in a major catastrophic event because they flood too. And particularly stormwater pond 3 is, it looks to me from this map, within the 100 and 500 year floodplain. So I'm not sure what's going to happen in that case. And just very quickly, I'll also mention we have concerns that it went from 5 riverfront lots to 8. 2 of them, as best I can tell from the scale, lot 46 and lot 95, have about 25 feet or 15 feet in the other case on the river itself. The state used to require a 100-foot riparian buffer. They dropped it to 50 under a lot of pressure. And the first 25 remain undisturbed, but the second 25 can be managed, you know, cut down trees, plant grass, and so forth. And that's just going to increase this pressure on these wetland areas. That's what we're afraid of. And then my final comment would be on the screening. It looks like there's a 40-foot buffer on the front. I'm not sure if it goes the whole length. I think that is required by the subdivision ordinance. And as Landon pointed out, there's a 10-foot landscape buffer of some plantings that blocks off the Gonzalez and the riparian buffers. And the Fontanas, as part of their contract, asked for the other buffer. We're still concerned that it's not really going to screen this development off from the other 2 neighborhoods that are totally different in character. But I'll leave that with you folks, and I thank you for listening to our concerns.
Thank you. If there's no other, the public hearing is now closed. Chris?
Mr. Chairman, I have nothing else for you unless anybody has any further questions from me or any other staff available.
I had a question for the engineer for Stroud. Oh, I had a question for Stroud, please. What's the elevation of the road in relation to the floodplain?
We're quite a bit higher. I do
Okay.
not recall what the 100-year flood elevation is off
Okay.
the top of my head, but we are higher. The property falls off hard towards the 100-year.
And the lots that are within the 100-year floodplain, how much fill do you anticipate to get them?
Not a lot. The front half of the lot, so we can get some drainage towards the road,
Okay.
not much.
I have a question for Landon about the,
Yes, sir.
what she was talking about, the buffer.
Yes, sir, Mr. Hines.
What she was talking about the buffer on that,
The berm up
the berm,
front.
yeah,
Yes,
Is
sir.
it gonna go all
From my
the-
understanding, it's not required up under the subdivision ordinance to have any buffers in single family, but we have, during the rezoning process, which is independent to this
Mm-hmm.
entirely, but we told folks what we were gonna do, and we're gonna do what we said we were gonna do.
So y'all are gonna stick to
So
that?
we're gonna have that berm up front for a nice landscape up front, and along the left-hand side as you come in where there's no natural buffer, we've got that 10-foot landscape. We had it as a buffer, but we're going to have it as an easement so the HOA can maintain that in perpetuity. And so individual lot owners, if they decide they don't want the trees anymore, they're not just going to be able to cut them down. It's going to stay there. And the HOA will be able to enforce that to keep that buffer on that side. And then the Fontanas all the way from 33 to the back of where their property stops right there at the power line is our plan to plant evergreens all the way down that line as well to create a buffer for the other areas. There's a huge field or pasture in between Holly Ridge and this property, so there is a bit of an open space there, quite a large open space between them, but this buffer we feel will help them out as well. So we have committed to that already, and we're going to do what we said we're going to do.
Okay, all right, thank you.
Is that buffer going to be managed by the HOA as well, or is that going to?
It's on the Fontana's property. They wanted it on their property so that they wouldn't have individual lot owners all the way down that property adjoining theirs. Same thing, cutting down trees or anything like that. So it's going to be planted on the Fontana's property, 6 feet over our line on the theirs. Yes, sir. And I would imagine anybody who buys it would more than likely keep it in between the neighborhood. So, but I can't speak for that portion in the future. But we're going to spend the money, put it up front, and our goal is, and our contract says with them, that when we close, we'll plant it. Doesn't give a specific date, but we anticipate doing that in the fall. Not now when it's 100 degrees, because it may not make it. So we'll wait till the fall and plant those in the fall, and that'll be well ahead of schedule of us starting construction, because if we do get approved, if you guys see fit to approve our preliminary plat, we'll still have to go through the construction plan process, construction of the site work, and things of that nature. So it should get a good head start before we get there and start building homes, is our goal.
Okay. Yeah.
How far back are you having to build the turn lane?
Gene and Steve gave us some requirements. I don't know exactly, but it was they ran the speed they took the speed limit and then the traffic count. But they did already give us a taper and storage, and we said whatever you want, that's what we're going to do. We didn't try to minimize that at all. When they told us that's what we wanted, we said okay, that's what we'll do in our meeting with them.
So there's going to be a right turn lane, and is there going to be
a left in? So it'll be, right now you got a 2-lane road, you got going both ways.
Right.
What we're going to do is we're going to widen the road out to have still 2 lanes, but you're going to have that center lane. So when folks are going towards Chocowinity from Greenville, or towards Grimesland from Greenville and Simpson, they're going to be able to come off into that turn lane and have an area to rest and wait for traffic to come to turn safely and left. While they're waiting, it'll have storage there for cars where they can continue on towards Grimesland and Chocowinity safely and not stall up traffic and make it an unsafe condition.
I see you've got phasing shown on here.
Yes, ma'am.
At what point is the recreation facility going to be built as part of this phasing?
It's already there. When we build it, we're gonna try. There's already a gravel road, if you saw from the pictures, that goes back there. We're gonna try our best during that phase 1 to get folks there. It may be phase 2 before we can get across that crossing. But when we sell homes to individuals, they will know up front what we're going to be providing to them, at what point we will be able to provide it. So we'll make sure that they understand when they purchase a property from us, this is exactly when the amenity will be active for those folks. But we do not anticipate getting the whole thing done and then having it, because we want to show them what they're getting. It's going to help us out as well, so, with sales.
Okay, thank you.
Sir.
Any more questions? Anybody have any more questions?
this is one for probably the engineer, to do with the stormwater management, the ponds and everything, and your drainage. As far as on this property, most of the water is draining in which direction? Towards the river? Is that how it's going to be?
Where the 100-year floodplain comes up between, is it Moss Bend, the neighborhood on the, you got it?
On the east side.
Neighborhood to the west,
West.
where that ties in, that's where the bulk of your runoff is going.
Okay, so it's all going, essentially all the ditches and drainage is all draining in that direction?
Yes, sir.
Okay. And you have three retention ponds on
Yes,
site?
sir.
Yeah.
Now, are they retention pond, like detention facilities, or are they stormwater treatment? Are they
They
detaining
will
a
serve
certain?
both. They will
they
be
do both.
sized on the BMP manual, but they will have storage for
For
the
like the 10-year storm?
10-year storm, which is
Okay.
required by the ordinance.
Thank you.
Thank you.
All right. Okay, what's the pleasure of the board?
I'll make a motion. I'd like to make a motion to approve
I
the
second.
plat.
Have a motion and a second to approve the plat as presented. So now call for the vote. All in favor, vote by saying aye.
Aye.
Was
All-
that everyone?
All opposed?
Nay.
Okay, so in this case, let's go again by a show of hand. All in favor, raise your hand. You got it, Tab? All right. All opposed? Motion carried. Thank you. Next up, we have Eric.
Thank you, Mr. Chairman. We're going to give you a quick update on our Southwest Bypass Corridor.
Hey, excuse me. Could y'all, if y'all don't mind?
This is just a brief update. It's our monthly update that we provide to you. We've got a few things that are coming up that are pretty important we want to make everybody aware of. So far, since we last talked, we have completed a few tasks. We conducted an online survey. We got approximately 340 responses out of that survey. So we felt like that was a good showing, a good turnout, a lot of good information. And also we began developing the draft future land use map for the study area. And this was based directly on a lot of the input that we received at the April public workshop that we held at PCC. So this is the draft map that you see here. You see it takes several different pieces. We had 4 different future land use scenarios that we presented at that workshop, and there was a number of different categories that were shown. People said that they liked certain things from one, didn't like certain things from others. So what you see here is really an amalgam of a lot of that data that we presented. And just to kind of point out a few things, as you see the bypass runs north to south. Up at the northern end, you see there's a lot of purple, and that's pretty much going to be designated for industrial development. And that also runs with what the city of Greenville and their Horizons plan showed for that area. But that's also where we see a lot of prime commercial opportunity, particularly with the intersection with US 13 right there. As you move further south, get a little bit more higher density or medium density development, residential development on the eastern side of the bypass. To the west, a lot of the comments that we received at that community workshop where they wanted to really preserve that agricultural feel and that rural feel of the area. So pretty much everything to the west of that bypass we're proposing to maintain as agricultural or some sort of low density residential development through there. So not a lot of commercial development. And one of the things too is that's also a byproduct of the utilities that are available. Many of the utility providers, in particular sewer, will be able to extend their utilities up to the bypass, but they don't have any plans to really extend it much further than that. So this will help with managing some of that development that's going to come off of that utilities. Then as we get further down to the south, as you get towards Ayden, it also picks up a little more industrial and a little more commercial development down around 102, and so that's reflected in that, and this also shows with the sort of the existing development that's occurring down there with the commercial around 102 and that industrial development that's right south of Ayden on 11. So some of the other things we're continuing developing our plan recommendations. We also conducted 2 steering committee meetings in May and June. We do have some next steps. The next one coming up is we're having a second public meeting. It's an open house style meeting. It's going to be next Monday, June 25th, from 4 to 7 p.m. at PCC. It's going to be in the Go Ahead Student Center, which is the exact same room we held the previous meeting before. It's going to be more of a formal presentation setting. We're going to have two presentations. It'll be the same presentation, but it'll be two different times, 4:30 and 6 o'clock. Because when we had the meeting the first time, we had a lot of people that showed up early at 4 o'clock. We kind of anticipate they'll probably show up early again, so that way, if they're there early, they don't have to wait till later on. They can go ahead and get a presentation, and those folks who can't come early will still be able to get that same information. So those are our next steps. Conduct the public meeting next week. Then we'll continue to develop that final draft plan. And then we'll be conducting our final steering committee meeting in July, with anticipating bringing it to the Board of County Commissioners for hopeful adoption in August. And so again, this is our information. The survey link on there, the survey is not active anymore, so that my fault for leaving that on the slide, but the project website is there. If anybody's got any or needs any additional information, it's been updated. It's got the dates and times for that public meeting next week. It's also got the future land use map on there and the character areas. So I'd be glad to answer any information or answer any questions if anybody needs any additional information on this.
I have one question.
Yes, sir.
We be traveling back and forth to Kinston, and I noticed when you pass that Aiden, I guess the first turn off there to the right, and look like you go straight up. Is it going to be you can be able to exit off of there? How you going to get over there?
It's going to be an interchange right through there, so you'll be able to get on and off.
Oh, okay, so they're going to redo. Okay.
Yes.
Yeah, because right now you're just sitting straight up.
Yeah.
Okay.
Yeah, a lot of the overpasses aren't in place yet, so
right.
It's still just the embankments that they're doing. But yes, there will be an interchange there.
Well, thank you.
Well, me and Miss Faye has been representative from this board to be sitting up here on this Southwest Planning Committee, and I'd like to commend Eric and also James and the whole planning staff. They've done an excellent job with this, along with the town of Ayden, also the town of Winterville and the city of Greenville and their planning department. Kind of the first time I've been in a setting that I think everybody's working very hard and very diligent, and I think we actually work well together, because I think it's been very cohesive. We've done a good job, and I think under the leadership of Eric and Jake, we've been able to maintain that. We really appreciate it, and kudos to Pitt County Planning. Y'all have done a great job.
Thank you. We appreciate it. It's been a lot of work. And I just want to remind everybody, this is a cooperative effort. We've got partners with not only the county, but the city of Greenville, Winterville and Ayden, as Mr. Hines mentioned, but also Greenville Urban Area MPO, NCDOT. We've got Chris Padgett from GUC has been helping serve on our steering committee board. So it's been a lot of work from everybody involved, but again, it's a big project, and it's going to have a lot of impacts in a lot of different areas, and especially on our municipalities too. So,
and yeah, again, the open session on the 25th, I recommend everybody go. If you have questions, they're going to be there to answer these questions. If you want to get your input in, this is a good opportunity to go out and let them know what you think and how you feel. Thank you, Aaron.
Thank you.
Next.
Next item I've got is a little more low-key. We're not going to make any decisions on this, but it's a training session. We had a training session back in April that was a legislative zoning decision session that was put on by the School of Government. It was very informative, and Mr. Hines attended that, and he asked that we provide some of this training material to this board tonight. Felt like it was something that was important that everybody hear and have a chance to learn a little bit. That was a 3-hour presentation that they did at the Ag Center that day. I'm going to try to keep it a shade under that, if that's okay with everybody.
Oh, so,
yeah. This is going to be
3 hours.
going to be a little more informal than some of our other items. If anybody's got any questions or wants to stop, ask anything, feel free to do so. We're going to have also, there's a sheet in front of you that's got 4 different training scenarios. We're going to refer to those throughout the presentation too. So with that, we'll go and get started. First thing we want to do is kind of just give a little background on planning in this state. We are not a home rule state. that means we follow Dillon's rule. So all of our powers are granted to us by the state. We can only do what the state tells us we can do. We can't take on additional powers or additional authority that are not delegated by the legislature. Through that, we have enabling legislation. And that sets limits and procedures for things like adoption ordinances, regulations, so on. It also establishes the police powers. Those are to protect the health, safety, and public welfare of the general public. And then we also have what's called a local bill, and that applies to specific counties or towns. So if a certain town wanted to sort of exceed the authority that is granted to them by the state, they ask the state for permission. The state they can get a bill, a local bill, and that grants them the authority to do that. The board, following legislative decisions, still has certain constitutional limits that have to be observed or considered. There's due process, there's equal protection, you have to treat people the same way. You have to make sure you're not taking somebody's property where you're depriving them of any sort of practical use or value of their property. And then there's also constitutional rights such as freedom of speech, religion, assembly, and so on that you have to consider.
Can I stop and
Sure,
go back
go
to that slide?
Absolutely.
Taking.
Mm-hmm.
Practical use, reasonable value. How is that determined? Because I think that's, you know, when it comes to a lot of what we see, that is really the thing in question.
Mm-hmm.
You know, I mean, even I'd say on the last Luke's Landing, I mean, that was one of the big questions. How is that determined?
Really, it's determined by, are you taking the value from their property? Are you reducing the value of their property below their market value, where it's essentially worthless? And it's Jordan, you want to? Jordan probably explain it a little better than I can.
Yeah, get the lawman up here.
So off the cuff, it's a pretty high standard for a landowner to meet to say that a legislative zoning action took their property. It pretty much has to mean that they can build nothing and use it for no purpose. It's a very high threshold for a landowner to prove that a zoning decision took their property.
So it would have to be backed by experts that both sides can agree were experts and so on and so forth.
Yes, there's a U.S. Supreme Court case, and it deals with oceanfront property in South Carolina, and that rose to the level of it because it was so restrictive. A huge lot was considered non-buildable, where they thought there could be portions of that lot that could support a structure. So it's pretty much rendering the property absolutely useless. So, please.
Okay. So there are several roles in planning. Primarily there are four. There's a legislative role, there's an advisory role, quasi-judicial, and administrative. Legislative is the governing body. That's the Board of County Commissioners. They're the ones that sort of adopt policies, they adopt ordinances and amendments. Their actions affect the general public as a whole. Advisory board, which is what this board is, you have no decision-making authority, essentially, unless you fall under, and we'll talk about this in a minute, with the subdivision plats, you have some administrative capacity that you serve in. But the advisory board typically sponsors planning studies, recommends policies, advises the board, but you don't make any hard and fast final decisions on request. The quasi-judicial, that's the Board of Adjustment. And their actions typically are focused on a special or a specific use for a certain situation. They have zoning appeals, variances, special and conditional use permits, and they have a whole separate set of procedures they have to follow, and that's mandated by the law. They're called quasi-judicial procedures, and they have to follow. So they're almost acting as a judge and jury in a request. So they have there's no ex parte communication. People that want to speak are considered witnesses, and they have to provide testimony. That testimony has to be supported by evidence. So it's a very different standard for that board than what this board hears. And then there's the administrative, and that's typically the staff. But again, this board, like we did with the subdivision plat, that is serving in a more administrative capacity. That's issuing permits, conducting studies, just having very non-discretionary decision-making authority. So what are some of the responsibilities of this board? Again, to conduct studies of the county and surrounding areas, and these are specified by state statute. These are not just things that are in on your rules of procedure. These are things that the state says, your planning board, this is what your responsibilities are. So you conduct studies of the county and surrounding areas. You determine objectives for those study areas. Prepare and adopt plans to achieve those objectives. You recommend policies and ordinances to implement. You make those recommendations to the Board of County Commissioners. So you're advising the board, including making any mandatory comments on zoning amendments. And then any other functions is directed by the Board of County Commissioners. You could issue conditional special use permits following those quasi-judicial procedures. One function this board has, preliminary plats. You could also review final subdivision plats if so directed by the board through the subdivision ordinance. You could designate redevelopment areas. You could serve as the Board of Adjustment if so designated. And also as any historic preservation commission if we had any historic preservation or historic locally designated areas. So again, the difference between the zoning decisions you make and the subdivision decisions you make, like we talked about with the previous subdivision tonight. With a zoning amendment, you are making a recommendation to the Board of County Commissioners. That's a legislative decision. You are acting in an advisory capacity in that role. Under subdivision, you are the decision maker. That's an administrative role. But there's no discretion in terms of that. So you have to follow what the ordinance says. You are approving it based off the requirements of the ordinance. And so the discretion you have under zoning amendments are pretty broad. You can take in public opinion. You can consider political views, whether it meets the comprehensive land use plan requirements. You have to look at what's reasonable, if it's in the public interest. Under the subdivision plats, you're only looking at whether it meets the standards of the subdivision ordinance. So that's where it falls in that administrative capacity. And any appeals under zoning, it's not applicable because you're just an advisory board. You're not making any decisions, so nobody's there to appeal your recommendation. There's a possible appeal process through the court system at the legislative end with the county commissioners, but there's no appeal of a planning board recommendation. Whereas under the subdivision plat, being a decision-making authority, there is an appeal for that, and that goes to the Board of County Commissioners under the subdivision ordinance. Does anybody have any questions so far? Okay. So also serving as a planning board, you have to make sure you're avoiding conflicts of interest. And the same with any board. If you're having any kind of direct, substantial, and readily identifiable financial interest in the outcome of zoning ordinance, you have to recuse yourself or abstain from any voting. So why do we plan? First of all, we have a comprehensive land use plan. That's the guide for managing the development and growth in Pitt County. And that guide that we refer to it every time we bring you a rezoning decision, it establishes a planning horizon of 20 years. So we're looking not just what it's going to be like next year or 5 years from now. What's the county supposed to look like in 20 years? What kind of growth are we proposing for that, or what kind of growth do we foresee for that? So that's what that guide does. And that plan is to manage growth and development. It's to account for population change. It's to minimize land use conflicts. To make sure that any kind of pressure on infrastructure that we're accounting for that, and we're making sure we're managing for that. To identify any kind of transportation issues, any kind of improvements to transportation facilities that might be needed. School facilities, making sure that we are appropriately managing development so that we're not overcrowding our schools immediately as developments come in. Also hazard mitigation and protection of natural resources. Economic development. Planning is a big factor for economic development. We want to make sure that as we're allowing businesses to come in, that we're allowing not just the right types of businesses, but they're locating where they should and where it's most appropriate for those businesses to go in. And also preserving our farmland. So as you can see here, population growth, just to give you an idea of how this factors in, this is population growth for 2010 to 2035, and this is what's projected. See Pitt County over here, there's a lot of hatch marks right around Pitt County. And those are counties that are projected to have a loss of population in the next 25 years. So you see Pitt County is one of the very few counties in the east that's actually expected to increase in population. So where are those people going to live, where they're going to work, where their kids are going to go to school? That's why we have to plan appropriately and why we have to make sure our land use plan is updated and that it's that the development that occurs matches that land use plan.
Can we speak to that as well? Sure. The comprehensive land use plan. You're planning for certain areas. Are there time frames for certain areas within that plan to be developed? You know, I mean, again, this subdivision we just looked at, y'all said it met our comprehensive land use plan. You know, however, the people that came here said it didn't. So I guess, can you speak to that, why it
Sure.
met the comprehensive land use plan?
So when we're doing our land use plan, we have certain goals and objectives that we're propose. They can be sort of specific, they can be very broad. Just some of the broad categories could be that we want to make sure we manage appropriate growth in areas that can support it, that have the infrastructure to support it. With a land use plan, again, it's got a planning horizon of 20 years. Doesn't mean you're going to write it and wait 20 years, see how it turns out, and then redo it again. Ideally, you'd like to update your plan about every 5 to 6 years, and we're probably getting close to where we need to update it again. But ideally, you would, as you're making those updates, those periodic updates, you're looking at those conditions, things that are changing. You know, where are you starting to see growth that you didn't anticipate 5 years before? Where are you starting to see improvements in transportation that are needed? Where are you starting to see things that are breaking down that weren't necessarily breaking down 5 years before? So you want to take those, and that's how you continue to grow your plan, or you continue to change your plan. You might do a major update every 10, 15 years where you completely rewrite the thing, but you don't necessarily throw the baby out with the bathwater. You keep sort of the same framework that you had before. But you do want to kind of monitor it and make sure that those goals and objectives that were in that plan, that as you're going those 5, 6 years, that it's continuing to meet those goals. And if you're seeing things change, that was one of the major reasons why we updated the land use plan this last time. And I'll kind of get into that a little bit. We started seeing the plan that we adopted in 2002 originally, that it wasn't accounting for a lot of growth in certain areas that we were seeing by the time we adopted countywide zoning, or after we adopted countywide zoning. So that's a good question. So yes, we do ideally want to keep monitoring that and not just keep it as a static plan and just let it go 20 years and then update it every 20 years. Does that answer your question?
Yes.
Okay.
I would say.
So, history of land use plan in Pitt County. The county's first land use plan was adopted in 1990. It established several goal areas with objectives and implementation strategies for them. There was the growth and development, land use, transportation, community services and facilities, and then natural environment. So 2002, just before we adopted zoning ordinance, did a major update to that 1990 plan. It also included appearance criteria to that. And then, as I mentioned, in 2011, it was almost 9 years after that first update in 2002, probably a little outside that window of where you ideally want to do those updates. We saw a lot of issues. One, we had countywide zoning that we adopted. We had a lot of development rezoning activity that wasn't really addressed in areas in that original plan. We had a lot of stuff kind of west of Winterville, down 43. We started seeing some stuff along 264 that just wasn't really foreseen in 2002. So along with that, there was also increased emphasis on community health and making sure that people had opportunities to go to recreation areas, were able to get fresh fruits and vegetables. So we added housing and community health to our plan, and to try to increase those opportunities for the people. So talked about why we plan. Why do we zone? Well, general statutes state also why we have to have zoning, or why we should have zoning. It's to protect the public health, safety, morals, or general welfare of the public, to encourage the most appropriate use of land throughout the county, also to prevent overcrowding, ensuring we have efficient and adequate provisions of utilities and infrastructure, conserve the value of existing buildings, and to provide for orderly growth and development. So the zoning ordinance, we talk a lot about the zoning ordinance, and we talk a lot about text amendments and rezonings. Those are map amendments. But what are the parts of the zoning ordinance? First, you have the text. And this is the actual body of the document where it tells you what the specific requirements are. And it's anywhere from how do we administer the ordinance? How do we enforce the ordinance? what kind of setbacks are applied to certain uses. So that is the text. Text also includes the permitted use table. It tells what is permitted where. Is an accessory dwelling unit allowed in the RA? According to the table, yes, it is. And there also mentions whether it has specific development standards, whether that's a conditional use or a special use. And we also have tables that establish what are the minimum lot sizes, what are our setbacks, what are those sort of more technical requirements for when we have a subdivision come before the board to make sure that they're meeting those requirements of the ordinance. And then we have the zoning map, which is what y'all deal with more regularly. You know, what is zoned what property is zoned what is permitted in that zoning district, where it's located. So as far as the history of zoning in Pitt County, it's a fairly short history. 2001, we had the Northwest Planning Area Zoning Ordinance. For those of you who probably, I don't know if anybody was on this board in 2001, but that was an area in the northwest part of the county, north of Pitt, north of the Tar River, experienced significant rapid residential growth, particularly manufactured housing. Had a lot of large manufactured home parks that came into place in that area. So again, when I talk about school facility planning, this really overnight almost overcrowded the schools. And so it was deemed that was an area that was needed to have some sort of zoning and some sort of controls going in there. It was also an area that was heavily impacted by flooding due to Hurricane Floyd in 1999. So there was a lot of factors for that area that really sort of precipitated some of these requirements. And then in 2003, we adopted the countywide zoning ordinance. And the main thing to take away from this is there's 11 general zoning districts and the same number of conditional districts. So the conditional districts, as we've dealt with previous requests, those are when you have a specific zoning or specific use that goes in it on a piece of land, and there's specific conditions that are applied to that use. So there are several considerations in zoning. This is the general statute. This is the planning statute for counties, 153A-340. Again, for the purpose of promoting health, safety, morals, or the general welfare, the county can adopt zoning regulations. And what those zoning regulations are supposed to do is to regulate and restrict the height, number, and stories, and size of buildings, percentages of lots that can be occupied, sizes of open space, densities of population, and the location and use of buildings, structures, and land. So when we talk about our zoning requirements and the things that we have in the ordinance, that is what it's mostly geared towards. It's geared toward where can you put things, what kind of setbacks do you have, how much open space is required. Again, just getting back to the types of zoning decisions that are made. Legislative, again, the Board of County Commissioners, they set those policies and requirements. Those decisions have impacts on landowners and neighbors and the public. So therefore, the state requires a broad amount of public notice and hearing requirements. This board, we have public comments when we have zoning decisions. If we have a rezoning request come forward, we still notify people and we still allow them to speak, but you're not really obligated to do that. You're not required to do that under state law. That's almost a courtesy that we provide, but it's an important one because then we can still have an opportunity for them to make their concerns heard. The quasi-judicial, again, these are applications of zoning policies to individual situations. Things like variances, special use permits, appeals, interpretations. Those are when you have, with a variance, if you have a piece of property and there is some situation that is unique to that property, whether it's like wetlands, whether it's some kind of natural environmental what's the word? It's something that is entirely unique to that property, not something that's in the whole neighborhood. And you cannot develop that property to meet the requirements of the zoning ordinance. You can request a variance because that condition is creating a hardship for you that is undue and is unreasonable. And so if a reduction in that setback would allow you to use your property and still meet the spirit and intent of the zoning ordinance, that is what the variance procedure is for. But that's a quasi-judicial procedure. There's also conditional use permits. Those are heard by the Board of County Commissioners. But because they are specific to an individual situation, they also have to follow quasi-judicial procedures. So when they go to the Board of County Commissioners, if it's a daycare, sand mine, those are conditional use permits, you still see them follow the same requirements. So people are sworn in, they have to provide testimony, they have to have evidence. And again, they have to require findings of fact. Those are the findings that the board uses to reach their conclusion for their decision, and they have to exercise a certain amount of judgment and discretion in making those decisions. And then again, the advisory board, the planning board. You recommend decisions, but again, you have no final decision-making authority. And then again, the administrative staff, or the planning staff, and the planning board in terms of subdivision plats. You're dealing with the day-to-day, more non-discretionary matters of implementing that ordinance and making sure that they're meeting the requirements of the ordinance. So we're going to move on to one of our scenarios. We're going to take a little break here, and we're going to go to scenario A, and just want to kind of get the board to think a little bit here. So a rezoning request is submitted for the planning board's consideration. A member of the planning board also serves on the Board of Adjustment and is familiar with quasi-judicial procedures against ex parte communication. Ms. Fay, we're not picking on you since you serve on the Board of Adjustment as well. This is just hypothetical. But in order to avoid any potential legal issues, the board member refuses a request by a neighboring property owner to meet and discuss the project. He won't even open the agenda packet from staff, which includes the staff report and application materials. He arrives at the planning board meeting with a clear mind and clear conscience. So what issues does this present, if any? And so just a clarification, with a quasi-judicial proceeding, since this board doesn't deal with those very many, you are not allowed to have ex parte communication. So the board of adjustment, or anybody that's acting in a quasi-judicial manner, they have to receive all the facts of the case and all the evidence at the hearing. So what sort of issues does anybody feel like this would present for a planning board member to act in that same manner? Are there any issues?
Well, did you say he lived next door?
If there's a neighboring property owner who wants to meet and discuss the project, under quasi-judicial procedures, they wouldn't be allowed to do that.
Right.
But he's on the planning board.
Right.
No, I wouldn't meet with them on that.
Okay.
He can choose to do that, but it's not necessary.
Right.
Right. There's nothing to say you can't do that, but you don't have to. So that's the difference. If you're serving on a board of adjustment or on a quasi-judicial capacity, you can't talk to that neighbor. You can't get their opinion on things outside of the hearing. Even in the hearing, they have to present evidence and testimony, and it has to be on the record. So if you choose to do that, that's fine. I would hesitate to say you shouldn't open the agenda packet for staff, but if you decide not to discuss a case outside of a hearing or outside of a meeting, that's up to y'all. Like I said, there's nothing against it, but we feel like you can choose to do that, but
Great.
but at least with the agenda packet, we feel like you should have at least an idea of the request that's coming up before you come in.
So we need to ask Tab, has Ms. Faye's packet's been opened before she gets in? Okay.
I'll be sure to open it.
I make sure it's sealed.
All right. Does anybody have any questions so far? All right. We're going to move on to conditional versus general zoning. I've got a conventional zoning in your agenda packet, but it's really our ordinance refers to it as general zoning, so that's what I've referred to in this presentation. But general zoning is basically just a general use district, and there's a list of permitted uses. That's your rural residential, rural agricultural, general commercial. There are no specific conditions placed on it. A conditional zoning, as you're aware, creates a zoning district with individualized standards for specific uses. So you have a general commercial district. Anything that's permitted under general commercial will be permitted on that property. You have a general commercial conditional district. It depends on what that property has been approved for. So if it's approved for a landscaping company, that is what's on it. If they want to change it to something else, they've got to come back, go through the rezoning process again to get it changed. Again, no conditions on basic zoning. You cannot impose any conditions on any general rezonings. If they're requesting general commercial, you can't request them to provide a certain amount of parking, or to provide certain hours of operation, or to have certain setbacks, or any other requirements based off any particular use. If it's general commercial, it's general commercial. And then as they propose a use, then it's reviewed for those standards at an administrative level. Under conditional zoning, again, reasonable conditions are allowed. And when I say reasonable, I don't mean just that you have to kind of limit what you can ask for them, but they have to agree to it. It's a voluntary process, and so not only does the board have to propose it, the applicant has to accept it. If they don't accept it, then that's a matter of contention, and the board can proceed how they want. But you can't just impose a certain condition that they don't agree with. General zonings can also include special use and conditional use permits. So if they rezone to RA, if there's sand mines are a conditional use in RA, then they could be permitted to do that, and then there's a separate hearing for them to approve that use. Conditional zoning, again, as I mentioned, is a voluntary process. So they can choose to do it. We as staff, we can't say, well, if you want to do this, you need to come in as a conditional zoning. We can recommend it and tell them that it may be more appropriate, but they're free to choose whether they want to go with a general zoning district or a conditional zoning district. And again, with that, the board, you can't turn around and tell them they need to do it as conditional. So when you're making a legislative zoning decision, some things you need to consider. You need to look at the land use impacts, not only on the property owner, but also the neighbor and the public. You need to look at the surrounding context and whether that use is appropriate, okay? Whether it's, if you're looking at a heavy industrial use, look at the surrounding area. If it's a major residential area, it may not be as appropriate. That's something you can consider in your decision. You also consider the consistency with applicable plans. You can consider, you don't always have to take staff recommendations. Same with the Board of County Commissioners. They can consider the plan and board recommendation, but they don't have to follow it. And then you also have to consider in a general zoning district all permissible uses. Somebody can get up and they can request general commercial. They can say, well, it's going to be a convenience store. Well, once it's general commercial, it can be anything under general commercial. It can be a convenience store. It could be a restaurant. It could be a nightclub. So maybe a convenience store is more appropriate, but maybe a nightclub's not. Well, you have to take that into consideration. You have to consider they may not do what necessarily they say they're going to do. Or maybe they get it rezoned, and 2 years down the road they sell the property, and then the next person's going to do something different. So that's what you need to think about in a rezoning. Things you cannot consider. You can't consider issues beyond the zoning requirements. And what that means is you can't impose a specific condition on a conditional zoning district for if the zoning ordinance doesn't require a certain amount of ingress and egress, you can't require them to add additional driveways onto a property. You can't require them to have hours of operation if the use doesn't require hours of operation necessarily. Or if you do require it, it has to be something that helps to achieve that zoning requirement. Okay. Again, for general zoning districts, extra conditions are unenforceable. So if they go into general commercial, you can't put an additional condition on something and have staff enforce it because that would not be permissible. You can't consider identity and ownership status. You can't say, well, we don't want to rezone this because we don't like this particular builder or we don't like this particular company that's proposing to operate on this property. You can't do that. You have to consider the use itself, not the identity of either the applicant or the property owner or their ownership status. You also cannot deny any kind of permit based off of their proposal to include affordable housing. You can do that to prevent a high concentration, but you can't make that solely your basis for your decision. So let's look at scenario B real quick. An applicant is requesting to rezone his property from rural residential to general commercial. During the hearing, the applicant states he's planning to develop a shopping center, and he displays a site plan with renderings of the building facade. The board discusses the land use impacts of the proposed development and approves the rezoning conditioned upon the site plan and the renderings. So what kind of problems do we have with this?
We can't put a condition on a rezoning.
Right. Right. This one's pretty straightforward. They're requesting general commercial. It's not a conditional zoning district. So there really shouldn't be any discussion at all in terms of a site plan or facades or any sort of specific requirements. Now, if it's a conditional zoning, yes, you could talk about those sorts of things. But under that general commercial, with just that general zoning district, that shouldn't be part of the discussion. So you should be considering all the uses in that general commercial district. So with zoning, there's also some protected uses. Family care homes, agricultural uses, and agricultural uses are almost totally excluded from zoning requirements under state law. It used to be, and we discussed this with one of our last text amendments, that we could regulate large-scale swine farms, and the Farm Bill last year took that requirement out. So pretty much any sort of bona fide farming activity is completely exempt from county zoning regulations. We get people call us, say, "I've got this chicken house next to me, it stinks. They're right up on the property. What can you do?" Not a lot. There's not a lot we can do about that. And like I said, it's not the answer they're looking for, but it's the answer we have to give them, because we don't have that discretion to enforce anything on uses like that.
Could you explain agritourism?
Sure. I was getting ready to get to that.
Okay.
Agritourism is a fairly newer concept, or a newer term, and people think of agritourism as things like hay rides, corn mazes, name anything else that is considered a part of a farm. But the state in recent years has gotten the definition of agriculture so far, or so broad-based, that just about anything you can do on a farm, with some exceptions, could be considered agritourism. It generally has to deal with whether it is there for the intent of the education of the public as to its agricultural use. There are certain things, and Jordan's here to talk. There's some court legislation he's going to inform you about.
Well, I'm going to save that for later, but I just wanted, since you asked the question, my handout has the text from the statute.
But I wanted to make sure that
I'll hit on it a little bit more in detail later, but I just want to let y'all know, since you asked the question, this handout is the quote verbatim from the law. So.
Okay. Yeah. I saw the handout, but I just wanted to make sure that.
Right. So the state, like I said, has a broad definition of agriculture that they include as agritourism. And there are some things that would be probably pretty surprising in terms of what is considered agricultural or agritourism. If you have a barn, or if you have a bona fide farm building, you can use that farm building for certain events, like weddings, and you don't lose your agricultural status. So pretty much if you're running a wedding venue as part of a farm and you're using farm buildings, that wedding venue is agritourism, and it is exempt from county zoning regulations. It's a big industry right now. We've got a number that are operating in the county, and it's a contentious issue. And particularly in some other counties, I think in Orange County there's one. I think it's this use. They've opened a wedding and event facility. Well, they're planting flowers, so they're agricultural. Well, their intent was really as the wedding venue, but because they're planting flowers and it's agricultural on that property, they fall under the agritourism statute.
That's my next question. Do we know how many do we have in the county? Do y'all know right offhand?
Not off the top of my head.
Uh-huh.
I know of probably at least 4 in the county, but I don't have an exact number. But it seems to grow every year.
Okay.
So, but yes, that's a good question. The agritourism. Now, that's not to say that anything you do on a farm is exempt. If you are running a separate business, if you have a machine shop that you're running on a piece of farm property, but it's not part of the farm, it's not you're cutting metal for a contractor or doing other jobs off site, that's not necessarily agritourism. You can still regulate that. If you have a stand, though, that is selling products that are derived from the farm. Say if you have an apple orchard and you got a stand and you're selling apple cider vinegar or you're selling apple juice, that stand is not considered retail, it's considered agricultural. So there's some differences, and it can be a fine line, but like I said, the state has seen it in their wisdom to give a broad exemption or a broad wholesale exemption to a lot of these agricultural uses. So moving on, though, some of the other uses, as I mentioned, with family care homes, cell towers, manufactured housing, sexual-oriented businesses, and signs, a lot of these are protected in that we can regulate the location and we can regulate setbacks from certain things, but we can't zone them completely out of the county. A family care home, if you're not familiar with that term, it's basically a group home, but it's for handicapped persons. And so they have broad protections under ADA and under the state in terms of how you can treat a family care home. And if they're licensed as a family care home, they have to be treated essentially the same as a residential use in all residential districts. So if you permit a single family home in a residential district, you also have to permit a family care home. So we can limit how far they are from other ones so that you don't have an over-concentration in one area, but we can't exclude them from certain districts.
Is it a half mile, or
Yes.
it all depends?
It's 1/2 mile from any existing family care home or group home.
Okay.
And we have the state, the Department of Health and Human Services, they have a listing that they keep of the licensed facilities in the county, in each county throughout the state. And we update that periodically so that we have that mapped, so that as people call in and have questions about if they can locate a family care home in this area, we can pull it up and see if there's one within a 1/2 mile.
All right. And then the other thing I wanted to ask is about, which we're seeing everywhere now, is solar farms. So they're not protected either, right?
They are not specifically protected. They are classified technically as a utility.
Okay.
And we have certain requirements for solar farms and certain permitting requirements, but there's not specific separation requirements from other solar farms. What we've seen recently is that within recent years, there was a big push to bring solar into the counties, and that was because there was a lot of tax incentives for solar farms to move into North Carolina. Well, those tax incentives have essentially expired, and so we've seen a slowdown. We haven't seen nearly as much interest in locating around here than we did. But yes, they are not necessarily a protected use. Cell towers are protected, not necessarily in where they can be located. We can place restrictions on cell towers, such as setbacks from other towers, setbacks from property lines, height restrictions. But we can't dictate how a cell tower operates. That's under the purview of the FCC. So we can't restrict them to certain frequencies or certain emissions. The FCC has the sole authority over those types of uses. Same thing with manufactured housing. We can restrict what zones they're allowed in or where they can be, but we can't exclude them totally from the jurisdiction. Sexual oriented business is much the same way. They are a constitutionally protected speech. So we cannot zone them completely out. We can place restrictions on the zoning. We can place setbacks from things like houses and churches and schools, but we can't say you can't operate completely in the county. And then signs also, we can regulate the size of signs. We cannot regulate the content. So anybody have any questions about any of these types of uses? Okay. So talk a little bit about the rezoning process. We have, again, with the general rezonings and with conditional zoning districts, it's virtually the same process. There's a submission of the application of the zoning administrator 20 working days prior to the planning board meeting. The main difference in that is that with the conditional zoning, you see there's also a site plan requirement for that. So they have to provide a site plan for the specific use when they make that submittal. The review by the planning board, recommendation to the Board of County Commissioners, again, state law mandates that all rezonings or any amendment to the zoning ordinance, whether it's rezoning or a text amendment, has to be reviewed by the planning board. And the planning board has to provide that written comment on plan consistency. Now, there's a lot of legal jargon, a lot of court cases that have dictated what has to be in that plan consistency statement. That doesn't necessarily apply to the planning board. That applies to the governing board when they're actually adopting that statement. Now, typically, we as staff, when we are drafting that statement to present to you, we include that and make sure that it is still meeting those requirements. But again, there's no legal mandate for this board to really go beyond just saying it's consistent with the plan. Following that, there's a public hearing by the Board of County Commissioners. In the public hearing, again, there's no mandate for public notice to be provided for the planning board when we have public comments. We do send that notice out, but the state does require, when it's the public hearing at the Board of County Commissioner level, that we do have published notice in the newspaper. Those have certain dates and time frames they have to be published in. There's a mailed notice requirement. The state basically says that for a mailed notice, you have to send it to all adjoining property owners. We go 500 feet out, so we pick up more than just the adjacent property owners. Then we have to post a sign on the property, which we do. And then with the review and decision by the Board of Commissioners, they're adopting that consistency statement. And they're the ones that are bound to the specific requirements of that statement under the law. And then following that, they're approving or disapproving that decision. That last box down there you see is if there's any kind of amendments to public water supply watersheds, we also have to file those with, it says NC DENR, but now it's DEQ, so Department of Environmental Quality. So as I said, consistency statement options. The general statutes say there are 3 things you can do with consistency statements. You can approve the zoning amendment and find it's consistent with the land use plan. That's pretty straightforward. Same thing with the second one. You can deny the amendment and find it's inconsistent with the land use plan. There is a third option that's a little bit more tricky. You can approve the amendment and find it is still inconsistent with the land use plan. And what you have to do is when you approve that amendment, you also have to, or not you, but the governing body has to provide some sort of explanation of why that amendment is now okay when your land use plan says it wasn't. And so they have to state what circumstances changed to make that amendment okay and to approve. And also, once it's approved, then your land use plan is deemed to be automatically amended to show that it's consistent with that land use plan. Now there's a fourth option that's not on here, and it's not in the statutes, and there's a lot of discussion going on about it right now. And that is you could deny the amendment, but find it's also consistent with your plan. So there's some question as to whether you can do that or not. The state, again, we are a creature of the state. We have the powers that are authorized to us by the general statutes. General statutes don't say you can deny an amendment and find it consistent with the land use plan. So I think there's a lot of work being done to try to amend that into the statutes pretty soon, or at least get some clarification on that. But as of right now, these are the 3 options that the state says we can take. Regardless of what you find, you still have to have your statement show that it is reasonable and in the public interest, or why that action you took is reasonable and in the public interest. So move on to scenario C. So again, after everything we heard, after a public hearing and deliberation by the Board of Commissioners, one of the commissioners makes a motion. I move that the rezoning is consistent with the comprehensive land use plan and is reasonable and in the public interest. Another commissioner seconded the motion, and it passed 9-2. So are there any concerns with that approved consistency statement?
No.
Not really. Go ahead.
They didn't state, I mean, they just said that it was consistent. They didn't make a motion to approve or deny.
Right. Their statement does not meet the standard for a consistency statement when it's adopted by the board. The consistency statement, you have to not only just say it is consistent, you have to say why it's consistent. You have to provide some sort of justification. Same with the reasonableness and in the public interest. You have to state why it's reasonable, why it's in the public interest. Typically, with those statements, you're going to want to pull something from the land use plan, or at least have some sort of criteria or something that's part of that you've considered in your decision that you're going to include in that statement. Like I said, we as staff, generally when we prepare the statements, either for this board or for the Board of County Commissioners, we're going to include that in terms of what we recommend as the consistency statement. Now, if the board follows or decides to go in a different direction, then the board then has to craft that statement themselves. Now, one thing I will mention too, when it comes to review, if the decision is appealed to the court system, the general statutes say that the consistency statement is not subject to judicial review, and it's not. But when it goes to a court, the court's already ruled, there's been several cases already in North Carolina that say they can review it to see if it meets that criteria, if it's provided a justification. they're not going to rule on the merits of your justification. They're just looking to see that it's there. So they're not going to say, well, this decision shouldn't have been approved because they said this was why it's consistent. They're not going to do that. They're going to look to see, was that justification provided? And if it is, then the rest of it's not under review or not subject to review. Does that make sense? Okay. So we have several other zoning matters. Again, we talked about the Board of Adjustment. We talked about variances and special use permits. Appeals, those are when the zoning administrator, myself, James, or Ben, we've made a decision or a determination on the ordinance and they want to appeal that determination. They would take that to the Board of Adjustment for them to make a determination, to decide if we were right in our decision or not. Then also conditional use permits, they're like special use permits, but the Board of County Commissioners, again, makes the decisions on those as opposed to the Board of Adjustment. So we have one last scenario, and I hope this one gets you all thinking a little bit. Scenario D, an applicant is proposing to rezone 150 acres of farmland that is currently zoned rural agricultural to suburban residential conditional district in order to develop a single-family residential subdivision. Sewers available to the property and lots will be a minimum of 12,500 square feet and will provide a variety of housing types, including single-family or affordable single-family homes and townhomes. The comprehensive land use plan seems to oppose and support the rezoning. The future land use map designates the property as rural residential agricultural, which encourages low-density residential uses and promotes the preservation of large tracts of prime farmland to ensure farming remains a viable part of the local economy. On the other hand, the plan also encourages providing well-designed neighborhoods that provide a variety of housing types, densities, and price ranges, and also encourages higher density development where adequate infrastructure is available. So the question is, how should the board reconcile those conflicting policies in the land use plan? And what factors should it consider in aligning its decision with the plan? So on one hand, we're losing 150 acres of prime farmland, but on another, we're meeting the objective of affordable housing with available infrastructure. So let's think about some of the things we can consider in a zoning decision. We can consider
recommendation. Your recommendation.
Consider the staff recommendation.
Right. That's a good one.
That's always my top choice.
That's right.
Adjacent property owner comments.
Adjacent property owner comments. So we can also look at some things like, we can try to take the surrounding area into context too. You know, this is a question where there's probably not really a right or wrong answer to this question. But there are, you have to kind of look at the request. You have to consider surrounding area. What is the context of where it's located? Are there other things besides the land use plan that can sort of make this appropriate or not? Is there other development that's occurred in the area? Are there transportation improvement problems or problems to the transportation network that it can't accommodate it? Maybe it is appropriate because of the sewer, but maybe it can't handle the traffic that's going to be generated by the development. So that's the kind of thing that when you're making these decisions and when you're looking at these requests, even though there are going to be two sides that maybe are weighed equally, what other factors are you going to look at to make that decision besides just the land use plan or just what the neighbors have to say? There's a larger context that has to be looked at. Does anybody have any questions?
You say who determines whether it's conditional or general zoning?
The applicant. We do not require them to submit a conditional zoning petition. We can recommend it, but if they decide to go to general, That's how it's processed. We can say, we tell people when they come to us, say this might be more appropriate as a conditional zoning district. Based off what they're proposing to do, what the use might be, what kind of impacts that use might have on the neighbors or on other areas. We say this might be more appropriate to do it as conditional, but we do not require it. So it is up to them to make that decision.
All right.
And with that, Jordan has a few things he's going to go over, so I'm going to turn it over to him if nobody has any other questions.
Turn it over to him.
Okay. Thank you.
Mr. Chairman, members of the board, they saved the best for last.
All
I'm
right,
going to try
now.
to be brief and get y'all out of here not too long.
Best for last.
So I have a couple interactive things for you. So as I mentioned earlier, I have this handout that has the definition for agritourism. And Eric hit on this, but just to reiterate, bona fide farms and agritourism are not subject to county zoning, but non-farm activities on a bona fide farm is subject to county zoning. And trying to figure out what is non-farm, what's agritourism, is pretty difficult, to be quite honest. We have a recent North Carolina Court of Appeals case that has, for the first time, gave us guidance on what agritourism means and what it might not mean. And I want to play the short video. This is the subject property that was the subject of the Court of Appeals case.
Welcome to Drake Landing, the premier hunting preserve in North Carolina, located in Harnett County. At Drake Landing, you can enjoy a full array of shooting activities for both the sportsman and the novice. Drake Landing was born from a love for the land and cherished memories from youth. Whether you like to hunt quail or pheasant or shoot sporting clays, Drake Landing is the place for you. Our sporting clay course features a 13-station trail with 2 traps at each station. Our 5 stands is a game setup with a menu at each shooting booth. The sporting clays are fully automated to allow shooters to trap for each other.
We've moved the targets around every 2 weeks, Bill, so there's no telling where they're coming from. There's a creek down here. A lot of times we'll send them down the creek, like passing duck shots, throw shondales up in the air, just all kinds of shots.
Our 200-yard rifle range features a 2-story bay area with 6 bays in all for shooting. We also have a 10-bay, 50-yard pistol pit firing range, a 25-yard auxiliary range, and 3 20-yard handgun shooting ranges. Drake Landing offers a great upland hunting experience with professionally trained dogs and guides. Various reserved packages are available for both beginners and sportsmen, including quail shoots, pheasant shoots, continental tower shoots, self-guided hunts, and even train your dog packages too. We offer deer hunting in bow, black powder, or regular firearms based on the season. Elevated box blinds, 2-man ladder stands, and ground blinds are available for hunting over soybeans, milo fields, oak ridges, and cutovers. Drake Landing is open year-round on a first-come, first-served basis. Just go to drakelanding.net and set up your next family, friend, or corporate event. Make a hunting memory that will last a lifetime at Drake Landing.
So that's Drake Landing in Harnett County. So the Andrews family in Harnett County has...
Oh, yeah. Hot temperatures and wet birds. Test the
I
pedal of...
apologize. Thank you. So the Andrews family in Harnett County has over 2,000 acres of land. They have the Andrews family farm. They farm that land. That's certainly a bona fide farm. But within that 2,000 acres, they have 140 acres that they devote to Drake Landing. The Andrews family owns Drake Landing LLC as well. So they presented to Harnett County and said that we are agritourism. We are not subject to your county zoning ordinance. The county agreed with them. Some adjacent property owners disagreed and said this cannot be agritourism. It's been a complicated procedural history on your screen. There's been 4 Board of Adjustment decisions in Harnett County on this one piece of property, 4 Superior Court decisions on this one piece of property, and 2 Court of Appeals decisions over about a 6 or 8 year span. So very complicated procedurally, but here recently the Court of Appeals ruled and said that Drake Landing does not meet the definition of agritourism that I handed out to you. It's a very long case, be quite honest. They basically they had a couple of different points that the court relied on. They said that the shooting activities at Drake Landing required the clearing of land, construction of artificial structures, alteration of the natural land, and found that those uses were inconsistent with the statutory listed activities. They also highlighted the fact that the statute specifically mentions activities like farming and ranching, but does not mention hunting or shooting. And so the court said, you know, if the General Assembly has listed some specific uses, they can list all the specific uses that they're envisioning. They did not mention shooting or hunting, so they said it did not meet the definition of agritourism. So this is the first case that we have in North Carolina holding something is not agritourism. It is a piece of guidance. We don't have any kind of similar proposals to this scale. The court also, I think, was kind of, they took note of the overall size of the project, and that, I think, troubled them. And just to mention, y'all, if you're out there and you want to visit an agritourism site, just a word of advice, there also, with some very minimal sign posting requirements, they're also exempt from personal liability. If you were out there and something goes awry, if they have certain signs posted, the facility is also shielded from personal liability. So if you're a consumer of activities, just might want to keep that in mind if you're visiting an agritourism facility. And I have one more case to talk about for you. And this is from Currituck County. And I forgot to mention, both of these decisions relate to Board of Adjustment decisions, which Eric hit on earlier. They're not really planning board functions, but just want to give them to you here briefly. So the question about whether or not something was a single-family home or not, the home or purported home at issue was 15,000 square feet. It had 24 bedrooms, sleeps approximately 50 people, and expected to rent for $20,000 to $30,000 per week out on the Outer Banks. To give you a visual,
that's a hotel.
That's the satellite overview of it. Here's an up close of it under construction. This one's it's a little bit further. You can't see it as well, but it's about 90% under construction right there. I think this is probably the best view. Kind of that's even closer to 100% of construction, I believe. So the issue in this case was the property owner applied for a building permit from Currituck County. Currituck County said that it met their ordinance definition of a single-family residence. And the adjacent property owner said, no, this cannot possibly be a single-family home under the county ordinance. So they appealed that decision of staff to the Board of Adjustment in Currituck County. At that hearing at the Board of Adjustment, the property owner, the person who wanted to build this large, I'll call it a structure, won. That decision was appealed to Superior Court in Currituck County. The person who wanted to build this structure also won in Superior Court, and they began to construct the large structure. The adjacent neighbor did not give up. They appealed to the North Carolina Court of Appeals. The North Carolina Court of Appeals said, no, Currituck, you are wrong. This is not a single-family residence. And it all hinges upon whether or not it's one structure with two wings or three separate structures. They're all these wings, I'll call them wings, are connected by roofs. So that was just a question of the Court of Appeals interpreting Currituck's specific definition of a single-family residence. So the person who wanted to build this large structure lost at the Court of Appeals, and they've already began construction. And so the Court of Appeals instructed Currituck County to revoke the building permit and tell the property owner to stop construction. It's already 90% complete at this point. And most recently, the owner of the 90% completed structure sued the county in a separate lawsuit and said, you can't tell me to stop. And the county ultimately won that decision at the Court of Appeals, and the county could tell them to stop. So These are just two recent cases that came out in the past 2 months, and staff wanted me to give y'all a quick rundown of them. Any questions from members of the board?
So it stops at the Court of Appeal?
I believe the decision was unanimous, which means they can appeal to the North Carolina Court of Appeals, but the North Carolina Supreme Court, but the North Carolina Supreme Court is not obligated to hear it, and in my view, probably would not.
So it all hinges upon the roofs not being connected?
And the court's interpretation of Currituck's definition of single-family structure. And I guess the takeaway for this would be if you're in the middle of litigation, don't start construction of a project just because you want it at the trial court level, because your opponent can appeal to a higher court.
Wow. So can they not make a design modification, a building modification to connect the roofs? And
I have no idea what will become of this structure.
Can't do no more construction.
And it's also on the part of Currituck that's only accessible by the beach road.
So this is like Corova? Or?
I'm not certain, but there's not a paved road access to it. So.
24 bedrooms. I don't eat something.
That's all I have for you.
All right. Well,
good. Uh-oh.
We have Mr. James Rose stepping to the podium. Come on down.
He told us he did the best for last.
I got you, Mr. Pitt. Okay, just a few things to kind of run through. There are a lot of activities that staff's involved with outside of your views here each month, so we wanted to bring you up to date. Certainly one, and I'm sure most of you have read through a lot of this information as well as what's been reported in the newspaper, but we did want to show you how the Bill Clark rezoning process went through to the commissioners. There was a public hearing. Staff was directed to hold a community meeting. We did that at the Village Hall there in the Village of Simpson. We felt like we got some concurrence there, not full concurrence, but you can read in your package starting on page 27 some of the ideas that came out of that meeting. And that was all given back to the commissioners, and they made their final decision back in May. So that's kind of the progression since you saw this particular item before I think that was back in March when you contended with it. The other item that we've been spending a lot of time with is the street improvement program in Woodmore Farms subdivision. Been through a bidding process. I only had one valid bid that was submitted, so we had to rebid, schedule the public hearing. We held the public hearing Monday night. After much deliberation, a lot of input, it was decided that the board would adopt the final assessment resolution. That starts the process in motion. We'll be contracting with the selected contractor probably next month, and we'll begin making repairs within the subdivision hopefully sometime later in the summer or early fall. And there's a couple of agenda items in there. Eric dealt with a conditional use permit, basically a daycare expansion, and that was approved at Monday night's meeting also. Another DOT agreement that was approved, and it's called Betterments, but basically it amounts to sidewalks that are be installed along Allen Road. That's on page 40 of your agenda package, and the county agreed to that. But the bottom line here, the city of Greenville will be paying the required match and maintaining the sidewalks, even if the areas are outside of the city limits. We've also, as most of you are aware, we have lease programs for our buyout properties. We've just acquired 5 additional properties from a recent buyout grant, and so we have also just gotten awarded monies for an additional 11 properties that will be going out to acquire due to Hurricane Matthew, so we'll keep you posted on that. The last item, page 43, snagging. This is also Hurricane Matthew related. For Little Contentney and Contentney Creeks, we went out for bids on those. Bids came back higher, came back more than what we had budgeted. So we will be rebidding that and restructuring or rescoping that particular bid package. So with that, Mr. Chairman, that's kind of bringing you up to date on some actions at the commissioner level. Your monthly reports are in there too, and some other items, and I welcome any questions that you may have.
Well, James, again, your staff did an excellent job on the training. We really appreciate it. I hope that the board got a lot out of it. When I attended it over at the Ag Center, of course, the 3 hours from the School of Government, it was good, but y'all did just good a job as they did with the School of Government.
The scenarios, I think, were point on, so I commend Eric and Ben both for spending a lot of time getting this together for you.
Maybe y'all want to take this show on the road to some of the municipalities that have
maybe. Well, we do. Eric probably will be presenting some of this to the town of Grimesland since we conduct zoning administration down there for that group.
I think that would be good. I hopefully some of them will reach out to you.
Okay.
Do it. But no other questions?
Motion to approve this adjournment.
All right. So moving.